and they will be given due considerations when the Joint Select Committee deliberates. So unless any member of the Joint Select Committee has any comment on these submissions, I propose that we continue to hear from the five presenters, starting with the Norman Manley Law School. So if there are no comments from the members of the Joint Select Committee, we're going to ask the Norman Manley Law School. Are you there, Norman Manley Law School?
Yes, we are.
All right. Could you please, sir, introduce yourselves and the members who are with you, and you can then start your presentation.
Very well, thank you. So my name is Iqbal Chevrier, and I appear alongside Miss Monique Morrison under the tutelage of Miss Kiva Chong as students, as stated before, from the Norman Manley Law School with our submissions as it relates to the possible amendments to be made to the National Identification Bill. Okay. So, Mr. Chair, if no questions are raised, I would like to proceed to the merits of our very short, we'll say, substantive. Thank you. So the submissions are generally focused on five sections, meaning section 5, 9, 11, and 14. As you would have indicated before, we had submitted a draft document, and we just provide, for the purposes of this discussion, a general overview as to what our submissions were. Sure. So we identified that in section 5 of the legislation, we're proposing that it be subjected to the data processing standards as outlined in definition of our Local Data Protection Act, to subject this authority that this governing body is supposed to possess to the standards as outlined in the Act. So the data processing standards are outlined from section 22 to 31. Primarily, they focus on what will happen for collection, processing, and possible disposition if the needs be. It was noted, however, that perusing the General Act, other sections were subjected to the authority of the Data Processing Act, but there was no specification made to any local or international legislation as it relates to the function and the power that would have been conferred in section 5. Moving on to the next merit of the substantive, we now moved to look at section 5, subsection 4. So section 5 contained the submissions as it relates to what powers the authority would be able to utilize. So we focused specifically, and we found problematic the clause to do anything or enter into any agreement with the opinion of the authority deems necessary to ensure its proper function. While the general clause is needed for effective management, we are submitting that the phrase "to do anything" be struck out and be substituted with a restrictive terminology, or to just begin from to enter into any arrangement. The possible implications that might be had as it relates to the inclusion of "to do anything" is a very subjective approach. And we believe that when we have a subjective approach subjected to the authority, that could pose a possible problem, because it moved from saying "to do anything" to saying that this anything that can be done will be of the authority would be in the opinion of the authority. And we at the Norman Manley Law School, in the committee that we had formed, found that was too subjective to be in an objective legislation in which we're trying to propose here. So the third substantive that was looked at that will be presented on by myself is that the offenses created in section 5.9 is too subjective. No guidance is given as to what will constitute a willful obstruction of the authority. So section 5.9, just for background, provides for what will happen to a person who tries to prevent the authority from performing its function as outlined in the preceding sections of section 5. It says that a willful obstruction of the authority will result in a custodial sentence. We're proposing that the custodial sentence aspect be removed, and an alternative be implemented as an alternative for a a financial compensatory measure be paid over, as was previously outlined, as is outlined in the submissions that we would have submitted. We further have 3 additional submissions, which will be made by my colleague, Miss Monique Morrison, and our tutor, Miss Chong. So those are the merits of my initial substantive, and I now hand over to Monique.
Okay, thank you. All right. Who is going to do the next one?
Good morning, everyone. My name is Monique Morrison. And joining my colleague here, just to clarify that these are not the positions of the law school, but the committee that was reviewing the document at hand.
Understood.
Okay. All right, so I just want to bring to light 2 points. I'm focusing on section 14. The first is a suggestion that we have that an individual's information should be purged if they make such a request. Under the Act, it seems from our reading that if an individual asks to be have their enrollment canceled, then their information is not purged from the system, but their enrollment is just canceled. So I don't know if the user would realize that in canceling, what they're really doing is canceling their access, but their information remains in the system. Based on my reading of it, that is how it comes across. So there may be some confusion in a user's mind or in a citizen's mind between what they're doing upon cancellation, which is basically restricting their own access to the system, but that their information would remain in it. If, of course, there are very good reasons for this, I would say that that be outlined so that citizens understand the system that they are using. And it is clear to them what that kind of terminology means. The other suggestion that I'll make before Mrs. Chong comes in is that in cases where a person has submitted inaccurate data, my apologies, the authority suspend the enrollment of the person for 72 hours as is provided for, and give the person an opportunity to correct the information. So as it is now, you can have your information purged from the system or canceled from the system if you have submitted inaccurate information. I'm a bit concerned about the people of poor understanding who may not be able to understand some of the nuances of different terminology that, they lack clear understanding. So they may be giving information about their the street that they think they live on, or the name that they thought they had at birth. But, because of cultural differences, it may be that there are, that's not actually their name, or that is not actually the name of the street, that kind of thing. So that you would not penalize the person, you would give them an opportunity, contact them, let them know 72 hours, you have this time or some other period as the committee may think appropriate to look at how this person can have their information corrected rather than them being kicked out of the system, because it may be that what they have done is erroneous submission and not something that is intended to defraud the system and the government. Now over to Mrs. Chong.
Thank you, Monique. So we are now moving to the section 11, which deals with the identity of information. And having looked at the entire act, we identified that it does define in the interpretation section, specifically at page 3, right? That information really means biographic, biometric, numerical information that may be collected under section 11. And our observation really is that we would like specifically for facial recognition or facial identity to be identified as what is its meaning and context to the public. And in our proposal, we would love to see that at least in the definition section, and more so if it can't be placed there in the body of the document, the actual explanation as to what facial identification means. And the suggestion was perhaps that we could define biometric data a bit more clearly, right? To identify that it means or resulting from a specific technical processing relating to physical, physiological, or behavioral characteristics. And that would be of importance to the public, we think, in being more willing to divulge that information when they clearly know what it means. We also examined what is actually required under Section 11 in terms of what is the biographic information that they require. And we cross-reference it with the NIDS policy. And on observation, what we noted is that it is quite expansive in terms of what it requires at Section 11A, you know, your full name, your date of birth, your place of birth, your name of your mother and father. And we were seeking clarity really as to why it needed to be so expansive in nature, as not, if it could not be sufficed with just simply ending at your place of birth, which is just the 4 requirements initially in the policy document. So that concludes our very brief submissions in relation to those specific areas of the policy. Thank you.
Thank you very much.
Chair.
Thank you very much, members of the Norman Manley Law School. I can assure you that there is a comprehensive response to you that we will send via email to you in due course, but your points will be examined by the Joint Select Committee, and it has been provided to us by the NIDS team. But at this time, I will ask Ms. Janelle Williams that you would just respond to these points made by the members of the Norman Manley Law School.
Okay, thank you, Chairman. And good afternoon, everyone. In relation to the suggestion at clause 5.4f that the words "do anything" be struck out, and the clause starts with the word "enter into any arrangements," this issue was highlighted in the submission by the Jamaica Coalition for Healthy Society. And the response was that this clause is intended to facilitate the efficient operations of the authority in the performance of its functions. The authority will have to utilize these powers within the parameters of the legislation, the Constitution, and the laws of Jamaica. With respect to the comment that clause 5.9 is too subjective, as no guidelines are given in relation to what constitutes willful obstruction, at this time we will refer to the CPC.
I know she's on, but it's a matter that we can examine later, okay?
Yes, very well, Chairman.
Go ahead, Johnny.
Yes, and as it relates to the penalty, the committee has indicated that it will be reviewing the offense regime of the bill. In relation to the comment about the identity information being too expansive and a justification is needed, this issue was also raised by the Jamaicans for Justice. And the response was provided that the data set is necessary in order to ensure that the information that is provided only once, will allow for the recognition of legal identity, as well as to satisfy know your customer requirements. A critical policy intent of the NIDS is to assist Jamaicans to access the formal financial system. This database is intended to strike a balance between the right to privacy via the provision of minimal information and also the requirements to access that system as outlined in the BOJ AML CFT guidance document, known as the identification of a natural person. With respect to your suggestion about a definition of facial identity, the bill makes reference to facial image, not facial identity. A similar issue was raised as it relates to facial image, and the response was as follows: that the policy intent is to capture a facial image for facial verification, to support the authentication and verification of an enrolled individual's identity. And this is pursuant to clauses 12 and 17. Regarding the general purging of identity information, this issue has been highlighted in several submissions, such as BOJ, MOCA, MNS, PIOG, and JAMBAR. The identity information collected will be retained in accordance with the provisions of the Data Protection Act, as provided for in the applicable retention schedule. And the committee has indicated that it will revisit this issue. With respect to the issue raised at the cancellation of enrollment about the authority to suspend the enrolled individual for a period of 72 hours to allow for verification of the information, this issue was also raised by Emundo Henez of Jets Limited. And the response was as follows, that the bill provides a discretion to the authority as to whether to cancel where inaccurate information is found. This would be an administrative exercise based on the nature of the inaccuracy, which may be detailed in regulations or standard operating procedures as applicable. And that completes my response, Chairman.
Right, thank you very much, Janelle. I think the CPC, Judith Grant, are you on, Judith? If you're on, could you turn on your video? And then you wanted to respond to that clause that was brought up by the Norman Manley Law School. I think it is 5.9. We can't hear you, Judith.
Thank you, Chairman.
Wonderful. Go ahead, Judith.
Yes, so that's the issue dealing with the mens rea of willfulness. That again is a policy matter as to the mens rea required, but usually the requirement of willfulness is to prevent otherwise innocent acts from being classified as obstruction. So I think as a matter of caution, it would be advisable to retain the reference to willfulness. Exactly.
Otherwise, negligent matters could be prosecuted when it was not intended. All right, thank you very much, Judith. I don't know if any other member would have any issue to raise. Just want to thank the Norman Manley Law School for your intervention. Bear in mind, a response, a more comprehensive response will be sent to you. And if you have any further comments on it, you can always send it to the Secretary at Parliament. So thanks to the Norman Manley Law School for their intervention and also their submissions. We're now going to ask the Youth Advisor Council. Are you there? Youth Advisor Council, are you there?
Yes, Minister. Good afternoon.
All right. Could you just indicate who you are and who is with you, if anyone?
Very well. Good afternoon, Minister. Good afternoon, members of the Joint Select Committee and other colleagues. I am Malik Kellier, and I am the chairman of the Youth Advisory Council of Jamaica. With me is Ms. Annabel Jones, deputy chairman, and Mr. Stephen McCubbin. We're so grateful for the opportunity to share a few brief points on our observations on the National Identification Registration Bill. Now, we would have conducted focus sessions with young people across the island virtually, as well as with our own 16-member council to come up with our submissions. And the main or substantive points that we have raised are regarding the implications for enrollment based on our analysis of Section 10, Information Security Section 23, and the recommendation, as we've heard a while ago from our colleagues from the Norman Manley Law School mentioning purging, but the need our colleagues have reflected for the word purging to be defined based on how it is used, and suggested rephrasing of two specific subsections, Section 5.7 regarding the authority's work regarding persons living with disabilities, and Section 24, subsection 5 regarding disclosure of information. I'll just quickly touch on the point regarding Section 10 about implications for enrollment. We appreciate the now voluntary nature that the Act is to provide for. However, from the respondents and members of the Council who would have reviewed the bill, The concern was, while it is voluntary and we are trying to assist as well the government now with even the buy-in to the voluntary nature of the bill, that will become an act. What will happen when persons who do not take on the national identification or the NIC card, as you have shortened it, Minister, how will that affect them with their engagement with public and private sector organizations is a concern, because persons felt if there is the buy-in and now public and private sector allows us now to use it instead of the other forms of identification that are currently being utilized, then persons who have not voluntarily signed on to use the same will feel the need or be forced to sign on. And then that will become what the respondents have termed an artificial voluntary nature to utilizing the NIC or the NI card. I'll turn over now to Miss Annabelle Jones, who will discuss very quickly.
If I might respond to that last point you made, though.
Yes,
bear in mind, as I said earlier, you may have heard me at the beginning, that there are up to perhaps close to 1 million people without an ID, a means of identification. Many of them use a GP to verify their identification. Now, there are many institutions, private institutions, that basically decide whether or not to accept, say, the voter ID card. Many of them will accept the passport, but not many Jamaicans, not all Jamaicans have a passport. Many institutions will accept a driver's license, but not many people have a driver's license. Fine. And one of the things which you may not be aware of, the government has the greatest difficulty finding people in their communities, especially when they want to allocate benefits to them. You take, for instance, if I am allocating benefit to persons to assist with their housing, they want contributions. Now, we don't just give the people the money. We basically would indicate to the CDF, that is, provides the funds. But the CDF, that's a Constituency Development Fund, they send officers out to look for these persons so that it's not a phantom we have recommended, right? Now, when they go into the community and they are looking for John Brown, if they go into the big yard where we have given the address that this person is in, and this person, John Brown, has TRN, age, date of birth, everything, they can't find John Brown. And when you ask the people in the community about John Brown, they don't know John Brown. But if John Brown is known as Manayard, and you say, is Manayard here? They know who Manayard is, or who Sour Jack is, as the case may be. Now, John Brown may well say, yes, I am John Brown. And then you ask members in the community, do you know him as John Brown? They said, no, sir, we know him as Sour Jack. So nobody in the community can identify him as John Brown. So you see the difficulty and the need for this national identification, because close to 1 million poor people across rural and inner city communities have no means of identification. And invariably, they have to get a minister of religion or a justice of the peace to write a letter identifying them as the person with this birth certificate who went to this school. So we are really catering to a wide cross-section of Jamaica with this national identification. It was struck down because of its mandatory nature. We have made it voluntary, and we hope that, most Jamaicans, when the trust and confidence, is gained about this card, that it will be fully utilized. So I just made that comment in relation to whether or not government is going to use it or private sector. Because I just make that point because you can see close to 1 million people may want it. All right, thanks now. The next person who is going to continue your submission.
Yes, Minister. I yield now to Ms. Annabelle Jones, Deputy Chairman of the Youth Advisory Council. Right. Annabelle.
Good morning, Minister. Good afternoon, Minister Chuck and members of the Joint Select Committee. As stated by my colleague, my name is Annabelle Jones. I'll be going through the substantive matters that our submission covered. The first thing that we had indicated in our submission is the need for the inclusion of a definition of purging in section 2, the interpretation. Ask the Joint Select Committee to consider the following points. Section 11, describe the identity information that the term purge was utilized in section 14 to describe actions undertaken after cancellation of enrollment. We, upon doing further research and investigations as well as sessions, came to the conclusion that the definition of purging as it relates to the removal of identity information should be in section and not left up to statutory interpretation for the purpose of this act. The natural and ordinary mean. Okay, I'm going to turn off my camera because that probably will help the internet connectivity. The natural and ordinary meaning of
you're breaking
what we would consider that mere removal of data.
Turn back on your camera. Maybe.
Okay.
Maybe now we can lip read.
Am I clear?
Continue again.
Am I clear? Okay. We would like the joint. Okay, Minister. We would like the joint civil and ordinary meaning of commission does not equate to the destruction of the data. So based on this, we believe that it is best for a definition to be included. Additionally, when we were reviewing the bill, we noticed that the term facial image was used in section 11(1)(b)(2). We had suggested that a definition, the reasons for this is because in doing further research on the biometric devices that are able to capture facial imaging, we have noticed that from one particular manufacturer, Multicheck C, this device is described as an extremely flexible and portable biometric device that can be used and collect information such as fingerprints, iris, and in our review of the previous bill, the 2017 bill, that the NIDS bill had made room for the collection of information, biometric information such as iris and retina scan. We wanted to clarify whether this biometric data under the broad terminology of facial imaging, given the types of biometric data collection device.
Okay.
Mr. Keller, do you have anything else to add? I'm finished from the main substantive points.
You want to add anything, Mr. Keller, to add what Annabella said?
I know her feed was going, but I know the main takeaways were, as she had highlighted, the definition for purging, which was a concern because of how it was utilized, as well as facial images. While we understand that facial recognition was made mention of, the council recommended that within section 2 of the act, facial imaging could be expanded into facial image, my apologies, could be expanded in terms of the definition provided within section 2. Additionally, Minister, the other two reference or recommendation points we had were with regards to the rephrasing of section 5.7. Now, section 5.7 concerns the roles of the authority or the National Identification and Registration Authority and speaks about specifically in section 5.7 that in the performance of its functions, the authority shall have regard to the needs of persons living with disabilities. And the council and the members, because we had a good representation across youth population or populace to include persons living with disabilities, thought the have regard did not have as much force or weight as a shall take all reasonable steps to cater towards their needs. That would have been the additional points for us.
Wonderful. Thanks again. We're going to ask Ms. Janelle Williams again to respond. And what you could do, Janelle, Annabelle broke up a bit in her presentation. So Janelle, can you just, in responding, just indicate the points that you're responding to, because I know that the NIDS team consider the submission fully. So Janelle, are you on?
Yes, I'm on, Chairman. Okay, so as it relates to the recommendation on the inclusion of a definition of purging in the bill, at this time, the team will refer to the CPC on that matter, and as well as the suggestion to rephrase clause 5.7.
Okay, you want the CPC to intervene now? CPC,
Yes, Chair. Well, really, again, these are policy issues, but with respect to the definition of purging, again, the ordinary meaning would mean to remove completely. So it doesn't contemplate retention at all.
Go ahead, Judith.
Certainly, that's to be contrasted with identity information where registration is cancelled at the instance of the enrolled person. In that case, processing would be prohibited, except insofar as permitted under Section 24 of the Data Protection Act, which permits processing for the prevention of identity theft or other fraud. So one would have to consider in determining whether purging is an accurate term with respect to persons who are ineligible for enrollment or where the information is inaccurate, whether there's any rationale for retaining that kind of information in the database, and would retention of that kind of information be consistent with the data protection principles?
Right. My understanding, you can explain, Ms. Janelle Williams, that if the person cancels the enrollment, then that person's information is no longer on the national, on the NERA, sorry, on the national database. So to the extent that a bank or anyone seek information about that person, it would not be on the national database. So the person's information will be removed. That's a concept of purging from the national database. But bear in mind that the person has a national identification number. And if the person seeks to re-register, well, once they cancel, they have to hand in their national identification card. But if they seek to re-register, then that NIN will be restored. That is a national identification number that that person had before cancellation. That NIN will be restored with such additional data when they seek to re-register. So, but once they cancel, the information will be out of the system, but the card which they surrender will be kept in the event that they seek to re-register at any time during their lifetime. And indeed, that number, when that person dies at any time, then that number retires with that person. So I just want to reiterate, it's a unique identification number, the NIN, and once you get it, absolutely no one else can get that number. And if you person cancels and seeks to re-register, that is the same number that they will get. Okay, Janelle, you want to continue or you had finished the response?
Yes, I'll continue, Chairman. With respect to their concern about facial image, the policy intent is to capture a facial image for facial verification to support the authentication and verification of an enrolled individual's identity. And this is pursuant to clauses 12 and 17. I know they had mentioned about the security of information. So with respect to the council's concern about the security of information, the common practice is that mission critical systems are hosted in Government of Jamaica's data centers. And the security of the NIDS solution is hinged on the National Institute of Standards and Technology and the Cybersecurity Maturity Model Certification, among other standards such as the ISO 27000 series and COVID 5, which are incorporated in the NIDS acceptable use policies and guidelines. Yes, and also in relation to the disclosure of identity information, there may be scope for further clarity as it relates to the disclosure process and certain safeguards and the prescription of regulation to outline requisite details. And consideration may be given to this by the committee. At this time, I have no further comments, Chairman.
Thank you very much, Janelle. And just to indicate to you, Mr. Kelly and Annabelle, that we're going to, the point-by-point response was prepared by the NIDS Secretariat, and I will ask them to email to you this point-by-point response, and this point-by-point response to each of the points you made will be available to the committee when it considers each section. I'm making this point because at the end of all the presentations, the NIDS team will present us with a matrix of all the submissions and the concerns expressed by the various presenters. And if you see any matter, when the Secretariat sends this to you, if there are any other concerns, you can always respond to the Secretary at Parliament, okay? So thanks very much for your contribution. And, all right, and thanks to you and Annabelle. So the next presenter will be Mona Law. Is Mona Law there? Mona Law?
Yes, yes, we are. Thank you, Chairman.
Hi, nice to see you. Right. So just introduce yourself and the members of your team. I seem to know you.
Yes, you do. Thank you, sir. Well, I'm Shazida Ali. I'm the Dean of the Faculty of Law at the UWI Mona, and I'm joined by my colleague, Mr. Andre Shackelford, who is a lecturer in the faculty, and he will assist me in presenting this morning. And first of all, I'd really like to thank you for the opportunity to make a contribution in regards to this bill. And we hope that in future we'll be invited to make further contributions in relation to other bills as well. So we have a PowerPoint presentation, and I don't know if we can be permitted to share it at this point.
Right. The administrator will, who is on it, I'm going to ask him or her to allow you to share the screen. So see if you can try.
Okay, I think, okay, there we are. Thank you. Right, so if we move to the next slide, we have prepared a brief executive summary in which we just wish to highlight, the fact that we recognize that the bill is intended to put in place a useful national identification system for Jamaica. We recognize, for instance, there are certain provisions which may be challenged in future. And so we hope that by identifying them at this point in time, the bill can be refined so that when it's law, it can overcome any such challenges. One of the things we recognize is that it engages the constitutional right to privacy. And we know that such interference would require certain justifications. So we will examine in the course of this presentation the following: issues in relation to ambiguity and vagueness that may be present in the bill. And these may in fact exacerbate the privacy concerns. We'll look at the issue of proportionality within the context of a necessity analysis. In other words, whether all the information that is required under the bill is indeed necessary for it to achieve its objectives. We'll also highlight the overlap between the bill and the existing Data Protection Act. And then we also want to point out that the bill incorporates certain offenses which fall within the Proceeds of Crime Act, the POCA framework, which we do not think appear to be appropriate for inclusion in this bill. And finally, we had pointed out certain drafting issues, but these were put in our written submission and we won't repeat them here. I'll now invite my colleague, Mr. Shackelford, to present on the next slide. Mr. Shackelford, thank you.
Go ahead, Mr. Shackelford.
Good afternoon, Minister. Good afternoon, members of the committee, and good afternoon, colleagues. This will be very brief. The likely operation of the national ID system, I believe we're all familiar with the idea that there'll be a request for a good for service, and with what we can call for now, quote unquote, consent of an individual, an authentication request ought to be made to the authority. And that authority ought to provide some sort of verification result, and founded on that, there will be the delivery of a good or a service. One of the things that we will highlight in the presentation is that the nature of the verification request, or the authentication request, I should say, from the public or private entity isn't entirely clear from the bill. And this is one of the issues of, I would say, vagueness, which props up, which, as we say, can exacerbate the privacy concerns which emanate from the bill.
Right, so if we could move to the next slide. So we of course accept that the Jamaican Constitution protects individuals' rights to privacies in many areas, including one's persons, property, private and family life, home and communication. And the proposed system would naturally, of course, cause some interference with some of these privacy rights. This type of interference may come, for example, from what is called physical or spatial interference from the collection of the fingerprints, for instance. There may be informational privacy concerns stemming from the storage and processing of electronic data. And to be permissible, these interferences must be basically demonstrably justifiable in a democratic society. And so we need to have an assessment of whether the system that will be created by the bill and its operationalization is indeed proportionate to the interference that may be involved. And just to add that, simple administrative efficiency is generally not a strong enough reason for the justification.
All right, and continuing from that, just to highlight that interferences with constitutional rights actually happen all the time, but they're very often justifiable. If you take, for example, CCTV camera footage, and let's just say it's in a public sphere in a government office, that interferes with the right to privacy, but ordinarily be justifiable because its reason is security concerns and is rationally connected to that reason, and it's a proportionate way of going about protecting the security concern, especially if the CCTV footage doesn't last forever and ever into eternity. So just to highlight that interference doesn't mean something is ostensibly bad or terrible, but once there's an interference, there ought to be a proportionate justification. And as it relates to information, especially electronic data, this gives rise to informational privacy concerns, and those concerns are often tied to potential risks. So not just the actual things which are happening, but what can happen. So there's often a connection to potential risks. So systems have to be put in place, or ought to be put in place, to ensure that potential dangers associated with collating, combining, and manipulating data are not realized. And that's a sort of theme that underscores some of our presentations. So some features of the system, if left unchecked, would have the potential for others to draw very precise conclusions about individuals' private lives. And that's a sort of scenario which we want to see protection against. So we will talk broadly, I think, in thematic terms rather than necessarily going into individual clauses and reading words into them or suggesting reworking, but talk about broad issues which arise from some concepts which arise in the bill. And one of those broad ideas is the collection of information. And this is the collection of identity information, which is guided by Clause 11 of the bill. Now, Clause 11 provides an array of information which may be required under the Act. It's severely condensed in comparison to the previous one, which was struck down in the 2017 bill. But this one is certainly does contain quite a few items of information. And unfortunately, the bill uses the language that the authority may request or require certain identity information. And that, we believe, imbues the bill with a certain measure of vagueness and ambiguity, in that when will certain information be required, Will a fingerprint be required all the time? Will a facial image be required all the time? Will TRN, NIN, so on and so forth be required all the time? Or is it that, as a matter of policy, everything is required, save what an individual might not have? So, for example, if you don't have a NIS, National Insurance Scheme number, you don't provide it. So the broad idea there is left uncertain, and it's certainly problematic for such an important feature of the bill to be left as a matter of discretion to the authority. And we would recommend that something like that not be left to subsidiary legislation either, especially if it's the sort of subsidiary legislation which is amenable to easy changes and easy tweaks. Another point which may be made is about data sharing by public authorities, and I'd ask the Dean to step in here.
Right, so thank you. So the data sharing aspect of it, the bill appears to contemplate data sharing amongst public bodies, and we recommend that the parameters for sharing and restricting the further use of the data other than for the purpose for which the data is shared should actually be prescribed by the legislation. We just wanted to draw your attention to a parallel. For instance, Section 12 of the Financial Investigations Divisions Act allows the Chief Technical Director, subject to the approval of the Minister, to enter into contracts or MOUs with other public bodies in Jamaica or overseas for the purpose of exchanging information in accordance with that act. And so Section 12 of this act actually sets out the conditions for such disclosure and limits the use of that information by the entity that receives the data. So we recommend some sort of similar parallel.
As it relates,
may I just ask you, when you say Section 12 allows you to share, look, if you look at the side notes of Section 12, it speaks only of verification of identity.
No, I'm sorry, I meant Section 12 of the FID Act.
But
I was recommending that you the committee could consider that section for assistance in terms of coming up with a framework.
But from my understanding, having been in this for quite some time, is that no data will be shared by the NERA with anyone, and any data that could be requested from the NERA would have to go, only the police could request some information, and the police would have to go to a court, the judge in chambers, to request specific information. And in order to get that specific information that it required, or the commissioner requires, they would have to demonstrate that they have tried every other method to get that information and was unable to get the data. And that doesn't mean getting information like, say, we need the fingerprint or we need the facial recognition, because those are the verification. But my understanding is like the data saying, could you say what is the name of the mother of this person who is on your register? Because they can't find the name of the mother. Why do they need the name of the mother? It may well that this person is involved in fraud and putting all of their assets in the name of the mother. And they can't find the right name of the mother, including date of birth, etc. So that to the extent that the Commissioner of Police persuades a judge that in order to investigate fraud, that they need this information, that's the only basis on which the NERA would release, say, the name of the mother and in a particular about that person information in regards to his or her mother. You see the point? In other words, as I understand it, this data that is collected, although it gets it, are verified from other bodies such as the electoral office or the electoral office, or from the registrar general, or from the wherever, in order to put the data in. Once they get the data, they're not going to share it with any other body. I don't know if that's your understanding.
that is our thinking. But the example you gave, for instance, if the information is received from the electoral office or from the registrar, what provision in the act itself precludes the authority from using that information for another purpose? So it was just really to expressly set out the parameters for use of the information that is received. So there could be an information sharing arrangement amongst the different government entities, but if it could be set out in the legislation, then there will be no doubt or no question that once the information is exchanged, it is only to be used for the specific purpose for which it was given.
Well, I will ask the NIDS team to point out where it is clear that this data, once collected, will not be shared with anyone or any entity, save and except the Commissioner of Police, where under Section 24, I believe it is, he goes to the goes to a court in order to get that information. Okay? All right, continue, please.
Thank you. I'll ask Mr. Shekhar to continue.
Thanks for that. And if I may just add a few more points on this general topic. The contemplated use of data may not be for seemingly malevolent purposes. That's from the point of view of a citizen, but seemingly benevolent purposes from the point of view of the government. And across the Commonwealth, it's being, across governments, not even per se the Commonwealth, it's been recognized that private entities have the ability to manipulate and use and juggle data in a certain way so as to achieve certain deliverables and improve services, so on and so forth. And the question has arisen as to whether public entities may have the benefit of doing such things. And the pushback against that, generally a set of privacy-related principles, including what's known as the Marcel principle of common law. That is, that information provided for a certain purpose ought to be used for that purpose only. And the concern, I believe, being raised here is that the bill perhaps isn't explicit enough in how information either provided or generated is curtailed. What are its channels of communication, so on and so forth, and what are the limitations, especially across public bodies, for what may be a benevolent purpose on the point of view of the government for doing so. And though I've mentioned benevolent purposes, a problem can arise in terms of creeping erosions, in that something is done for a good purpose now, but a similar thing is done for a not so great purpose.
Yeah, but my understanding, you see, Mr. Shackelford, is that whereas in setting up the database of the NIRA, they will get material from all the different government agencies to ensure that the data that is collected is accurate. There's no question of the NIRA sharing that information with any of the other bodies in turn, save and except to verify identification. So to the extent that a private institution or a public institution like TAJ or PICA, the Passport Office, wants to verify that a picture belongs to XY, then the NIRA would verify. But it's not a question that PICA or a private institution will get any of the data at all from the NIRA. They will only get verification. Are you with me? So,
I understand.
Right. So, that's the concept of sharing. Whereas other public bodies will pass information on to assist in the development of the database. Once that database is developed on every individual, that privacy will be protected, and the only thing that the NIRA is authorized to do is to verify the identity. Okay? Not to share the information with anyone. Save and except the Section 24. All right, continue, please.
Very well, that might be an excellent segue into the next point being raised. That is the question of whether the items of information being collected are necessary. And as I believe you highlighted just now, Minister, the bill emphasizes identification and verification of identity at its core. So the question arises as to why the mass of information being collected is being collected. And perhaps key here is the ambiguity in the question of what verification of identity looks like. In other words, is it that, for example, fingerprint data is sent from an entity to the authority who then confirms a match on the system with certain other parameters, or is it something else? Now, I did attend one of the hometown halls, and someone from one of the technical teams, I can't recall his name at the moment, had said that there'll be no scanning of fingerprints. And this is just an example, that there'll be no scanning of fingerprints to identify individuals. So that then begs the question, why are fingerprints being collected? Because if at its core, the bill is about identification and verification of identity, but no fingerprints will be collected to verify identity, why are you collecting fingerprints? That's essentially the line of logic being raised here.
Yes, to the best of my knowledge, and I was at all of these town hall meetings, fingerprints being collected is for verification purposes. In other words, we're collecting fingerprints, facial recognition, signature. These are the three main items on which we will identify a person.
Okay, I accept that I may have heard incorrectly, but perhaps that was the case. But I did make a note of it, that it was said a bit stridently that no entity would be asking anybody to scan the fingerprints at one of the town halls. Unfortunately, I don't have my notes with me right now. So that goes on to highlight the next point, that the nature of identity verification within the system is going to be key. And that, once again, isn't something that ought to be left to external policy. It shouldn't be left to the authority, or should it even be left to subsidiary legislation. We would suggest that it's something which ought to be stated clearly in the bill. That is, what is this mechanism for identifying information? And I believe one of the clauses in the bill had stated that no identity information will leave the authority. So certainly a verification is what can leave the authority, but we still need, I would say, more details as to that process. And just to highlight from the Robinson judgment concerning the older iteration of the NIDS, one of the concerns raised by the Chief Justice, I would say again and again, were the questions of ambiguity within the bill. So we would make that recommendation.
Okay, continue.
Furthermore, a point was made by one of the previous presenters in the context from the youth fellowship, the youth arm, as to whether the bill is mandatory or not, and if essentially what may be raised are questions of false consent. Because the bill does use the language of voluntariness. That is, parties may be required to present the national ID number or card, so on and so forth. Well, the question then arises as to whether the enrollment in the system is required or will be required to access certain services which are essential. Is that a possibility which is left open by the bill? And one of the earlier presenters had presented the possibility of a negative listing, that is to say, these people ought not to require the presentment of this national identification information. And I would suggest that that actually may be useful. That is to prevent the exclusion of the citizenry from certain goods and services which might be considered essential. So once again, there are issues of ambiguity and vagueness in the question of accredited third parties, in that the bill says that accredited third parties may require the presentation of a national ID number or a national ID card. Who can be an accredited third party? Who cannot be an accredited third party? If we take the absurd, we could picture an entity which has monopolistic control over some segment of a market, requiring completely without any proper justification the presentation of national ID numbers or national ID cards. And certainly you wouldn't want to have the citizenry exposed to such arbitrariness. So I would suggest that we batten down this idea of the necessity or non-necessity of the national ID number or national ID card.
Well, if you bear in mind, you see, Mr. Shackleton, let us say, for instance, driver's license. Suppose the entity issuing driver's license require a national ID in order to verify who you are. And you say you're not interested in the national identification. What you will agree that the entity, the Island Traffic Authority, may well put you through a process to verify who you are. You agree?
Oh yes, I certainly have agreement with that.
And that could well mean that you have to get your birth certificate. You have to get everything that the national ID require. The Island Authority may ask you to go and do it. You would
certainly I would hope within the bounds of reason, but certainly, yes.
Right. And I mean, as you may have heard my earlier submission, what about those persons who have no identification at all?
Oh, don't get me wrong with it though. We definitely accept that the national ID card can play a role in filling a gap. I believe what we're doing is highlighting concerns, nevertheless. So sure, it can have benevolent aims and good ideals behind it, but that certainly doesn't eradicate the fact that other concerns might arise. I believe
and to the extent that you're right, I mean, anything new will have their doubters and skeptics. What is important is for the NERA, once it's set up, that over a period of time, that the trust and confidence is exuded, so that people will feel that getting a national ID doesn't expose them to unnecessary, investigation, risk, or invasion of privacy. So one understand the doubters, the skeptics, as to why this national ID is required. And that is why at the town hall meeting, from the act itself, we're saying this national ID is nothing more than an identification. It is not. I have resisted and spoken anyone who thinks that it is for criminal investigation. The answer is no. For instance, when the Jamaica Constabulary Force came here and asked that if they use, we said no, it is not set up for crime investigation. You're with me? Because if that is the case, the trust and confidence in it would be lost. You see the point? All right, continue.
I'd certainly say, Minister, that people do recognize, I would think, potential benefits from the system. However, there'll be a danger in characterizing those who raise, I think, legitimate concerns as doubters and skeptics, or rather people with legitimate concerns.
Well, fair enough. Continue. Is that it?
Oh no, there are a few more points to be made, but we should be wrapping up fairly quickly. Another concern which arises is in relation to transactional data. That is, the system will have the effect of generating a sort of metadata each time someone does a transaction which engages the national ID number, the national ID card. And the bill recognizes the production of such data, but there's certainly a lack of controls in relation to access and use of that data. In other words, you can imagine that someone conducts some business at a certain place, and there's created an electronic record that person A accessed a certain building, and perhaps you can then conjecture to do a certain thing. And you can have such series of events being generated on the system, and such transactional metadata has been recognized, I'd say, the world over as being capable, when analyzed, of allowing people to draw very precise conclusions about individuals' private lives. So the bill appears to be a bit lacking, I should say, in relation to any protections on transactional metadata.
Proceed.
As it relates to the disclosure of identity information, there are certain provisions in the bill. You find them in clause 24, which deal with the disclosure of identity information. There are two concerns which arise here. One is that the bill provides that identity information may be produced as under the bill or any other law. And the broad statement of any other law has the potential to allow for creeping erosions on any protection as to privacy. So that is something to be taken under consideration as a sort of broad thinking in crafting the bill. The potential of creeping erosions in relation to protections as time goes on.
You will agree that that section, specific section 24, is under the authority of the Supreme Court. What is released under section 24 is guided by the Supreme Court. In other words,
no, Minister, because it currently says the authority shall not disclose information stored in the database to an individual except 1, in accordance with the request of the individual concerned, 2, in accordance with the order of a judge, or C, as may be provided by this act or any other law. So the protection of a judge's discretion isn't applied to that provision.
Wilson did seem to respond to that.
Very well. And perhaps another item for concern is clause 24.2b of the bill, which has national security as a ground for disclosure. This was dealt with by the Chief Justice in the judgment in relation to the previous NIDS, where concerns were raised over national security matters often treated as nothing justiciable. And so we suggest that some thinking may be required for further controls that could be required in relation to such a ground. And perhaps philosophies could be borrowed from freedom of information legislation, which you'd find in other jurisdictions, such as the United Kingdom, that may provide some ideas, I would suggest. Additionally, I'll be very brief on this. Clause 11.3 of the bill creates an offense where without lawful authorization, a person collects identity information from an individual. That's a very cut and dry provision, and we'll submit that it steps within the realm of the Data Protection Act. And the Data Protection Act has a very nuanced framework for dealing with matters such as these. From sections 23, 24, and 25 of the bill, of the Act, the Data Protection Act, those provisions deal with the first data protection standard, which is fair and lawful processing of personal data. And this raises the question of lawful processing. And as I said, the Data Protection Act is a very nuanced framework. There are many different ideas and carve-outs and exceptions and quite a bit of discrete drafting in relation to that act. So I would recommend that this offense be revisited. And I do understand that it was said that all the offenses are being considered yet again. Another concern which arises is a practical one, and it's in relation to part of the destruction provisions. Clause 24 deals with the destruction of data coming from the system broadly, but it curiously provides for the destruction of data of convicted individuals. I believe it says within 3 months of someone's conviction, information drawn from the system ought to be deleted or disposed of or destroyed. And that seems to be problematic because the destruction provisions should of course apply to any copies of the data as well, not just a single copy, otherwise the destruction provisions would be completely meaningless. So if we take information from the system about a convicted individual, such as that person's name, then they're convicted. The idea that such information ought to be deleted seems impractical, so it doesn't seem to correlate well with the administration of justice. So perhaps some exceptions could be specified in that regard. All right. I'll now turn to the Dean to make some points in relation to POCA.
Okay, thank you. So paragraph 16 of the 4th schedule of the bill purports to make certain amendments to the 2nd schedule of POCA. And we submit that not all of these proposed amendments would be appropriate. So the objective of the 2nd schedule of POCA is really to specify certain offenses which, if committed, would deem the defendant to have a criminal lifestyle. And that is for the purpose of the post-conviction asset recovery provisions in POCA. Now, Schedule 2 is really intended to help the court to determine the extent of the benefit from crime that the defendant had derived. And so this presupposes that the offense in question is one that generates a benefit. In other words, one that can be calculated and shown to have made a financial gain for the defendant. What we notice is that some of the offenses that have been set out, for instance, in clauses 10, 7, 11, 3, and 17, 2 of the bill, that these do not appear to be financial offenses in nature. And so we question why they have been included in the schedule, where that schedule is meant to refer to offenses that are likely to result in a quantifiable benefit. So for instance, clause 10.7 speaks about providing false information. So the question arises, does the simple provision of false information result in a financial gain to the defendant? And if it doesn't, then it's not appropriate for it to be included in the schedule. By contrast, clause 19.3 speaks about, a situation where it is possible for the person who violated that section to gain some sort of calculable financial gain. And so that one we accept is appropriate for inclusion. But we highlighted the others, that's clauses 10.7, 11.3, and 17.2, because they include certain provisions that we do not think would result in a financial gain on the part of the defendant. And hence, it would not be appropriate for it to be included by reference to the second schedule of POCA.
Go ahead.
Yes, so that would be our submission in relation to the fourth schedule in the bill and its corresponding connection to POCA and the second schedule of POCA. Because that second schedule, which speaks to criminal lifestyle, is really about offenses that, really habitual criminals engage in, lifestyle criminals. That's the purpose of the second schedule. And somebody who simply provides false information when they're, getting the car would not necessarily. So I think it has to be more clearly defined what type of offenses you expect will result in the offender gaining some sort of financial benefit in order to make that connection to the second schedule of POCA.
Okay.
And the conclusions will be done by my colleague.
Very well. So in relation to our conclusions, sort of drawing some things together thematically, we submit, let's say, that there's some issues of vagueness regarding the items of information which are required for a particular individual, that is when and why certain information will be required, and what entities, whether public or private, may require the presentation of a national ID card or a national ID number. Some issues of necessity arise in relation to the items of information which are collected, and this is of course caveated by, if it's happening, any data sharing by public bodies, if contemplated at all. There may seem to be some issues of lack of controls regarding transactional data which could be generated by the system, and disclosure of identity information, which also has some elements of vagueness tied to in that regard as well. Also, as noted, the bill does seem to step somewhat into the detailed framework of the Data Protection Act, and we suggest that it ought not to. And we also recommend that the data of convicted individuals are not to be destroyed post-conviction. And as just highlighted, some offenses in clauses 10, 11, and 17 of the bill do not appear to be financial in nature and are not fit for inclusion in the second schedule of POCA.
Okay, now the PowerPoint presentation is different from your written presentation sent to us, okay? Can we ask that you send us a copy of your PowerPoint presentation, if you don't mind?
Yes, we sent it in this morning. It really seeks to expand on our written presentation. Right. So it's not entirely different, just an expansion.
It's just that it is clarifying a number of the points
yes.
written.
Yeah.
We're going to ask Ms. Kamika Facey to respond to your points. As I indicated, there is a comprehensive response that has been presented to the members of the Joint Select Committee. She will just highlight some of them, but the Joint Select Committee will have not only your presentation, perhaps including the PowerPoint, but also the comprehensive response from the NIDS team. But at this time, Ms. Stacey will highlight.
We appreciate that.
Yes.
Thank you, Minister. Good afternoon to you as well as to members of the committee, technical team, and colleagues. Okay, I'm going to go through clause by clause in the order of the clauses rather that are applicable. So clause 11, you had spoken to the high level of discretion and policy making left to the authority as a result of you're not being able to appreciate from the bill when certain information will be required, when it won't, and if it is that it's simply a matter of certain information being required, is it applicable to a particular individual or the authority being given a discretion? Okay, and we need to, so firstly, I'd like to point out that this particular clause is concerned solely with the collection of identity information for the purpose of enrollment, and it is at that point in time that the information will be required. As it relates to it's intended to provide the authority with the discretion to account for an individual who is not able to provide all of the requisite information for physical reasons. For instance, for someone who does not have hands, or who, though they have hands, you can't discern the fingerprints, for instance, with regard to the importance of collecting the fingerprints. And one example, right, so that is one particular example. So the authority, it is to an applicable individual, and it's also to give the authority to the discretion to ensure that persons are all able to enroll should they choose to do so. As it relates to data sharing, this issue has already been highlighted in previous submissions, and we again indicate that the point of the bill is to recognize legal identity. It is not to be a tool for data sharing or for crime fighting, and the collection of this information is to ensure that the person is indeed who they say they are prior to enrollment in the databases and in the NIDS itself. So any data sharing that takes place, it really would be from other entities, in that we would be utilizing some of the information that's already produced by those entities. It's not that we, the NIDS, will be giving out any information, right? That is very prescribed and prescribed in the bill. Only disclosure is as it relates to those under the disclosure provision under clause 24, right? And importantly, any data sharing per se, because we are utilizing certain other pieces of information coming from other government entities, would of course be with the individual's consent, and solely for that purpose to ensure that the data to be entered is accurate. Because if you recall, in that same clause, the NIDS team, the authority, is proscribed from entering information that's not accurate. So they have to ensure that they have to verify the information to ensure that it's accurate before it is entered into the system. Clause 11, traversing matters you had indicated competently covered under the Data Protection Act. And this you indicated, clause 11.3 creates a curious offense where without lawful authorization, a person collects identity information from an individual. And again, clause 11 must be read in its entirety. The offense is created only in the context where that person, that individual, is purporting to collect information for enrollment in the databases. It's not speaking to other instances. As it relates to whether or not, so we've moved on to clause 17, and you were indicating that the bill, the use of the language of accredited third party, you don't know who it is who can be an accredited third party, and it, as a result, it imbues the bill with ambiguity, who or what entities may request it, what protections exist against the individual being denied access to goods. And this issue had been previously raised by well, it had been previously raised. The committee has indicated that it will be looking at that regime again. However, it is important to note that there is an enabling provision to make regulations which would indicate exactly what is required and the types of entities that would be able to be accredited third parties. And that scheme would be detailed in regulations. As it relates to the disclosure of identity information, and this is at clause 24, you had indicated that the basis for the application or disclosure is necessary for preventing, detecting, and investigating crime, and also indicated that national security matters are often treated as factual and non-justiciable. And we just wish to point out that, yes, this issue has been highlighted by another submission, another entity who will be submitting later today. And the terms national security and in the interest of national security, yes, they would be construed in their ordinary meaning. Now, the consideration of the facts, however, that are provided to the judge would serve to assist the judge in the determination as to whether the disclosure is in fact necessary in the interest of national security. Further, the clause is in keeping with the requirements for disclosure as it relates to national security pursuant to the Data Protection Act. However, of course, it's something that is up to the committee, and so we are referring this issue to the committee. Right? As it relates to any other law, it must be remembered that despite the fact that there are issues of privacy, there are other laws which we are bound to follow, and we cannot, this bill cannot distance itself from the rest of the laws of Jamaica, just like we can't distance ourselves from the data protection regime, which does in fact allow for disclosure in certain circumstances. Those are the laws that we are speaking to. It's necessary to insert that sort of provision because it may very well be that they will have carve-outs that the authority will have to, despite the privacy considerations, adhere to. And we must also recall, I believe, and it must also be specified that the data protection regime is there that we have to be compliant with, and that the Data Protection Act will be, for want of a better word, the authority on what it is and the carve-outs that are there. As Mr. Sheffield indicated, the carve-outs that are there are quite nuanced, and the authority will be required to ensure that they are in fact in accordance, acting in accordance with those carve-outs. The board is there to ensure that the authority is conducting itself in accordance, and there will be the independent oversight authority to ensure that it is that the highest level of security is being maintained and the highest level of privacy and confidentiality is being maintained, even as we are mandated to act in accordance with any other law or under the Act. All right, you also indicated with regard to the question of whether the items of information collected is necessary, and this was with regard to the request for information or for authentication and verification services, clause 25. Now, as it relates to the information required, this issue has been highlighted, and it must be noted again that the information that is required has been drastically reduced. The information required, the data set is necessary in order to ensure that the information is provided only once, and that it will allow for the recognition of the legal identity of someone. It will also, for instance, satisfy KYC requirements and enable persons to be able to access all parts of society should they wish to utilize this mode of access. It does not preclude them from utilizing other modes of access, but it was specifically designed to ensure that it would allow for this access. As it relates to lack of controls on disclosure with respect to transactional metadata, so there are several levels of security that the authority will be required to adhere to. or rather to put in place and then to adhere to, and that's under section 23 outlines some of those, right? In addition to encryption, anonymization, and pseudonymization, all concepts, by the way, which are under the data protection regime. And in fact, anonymization is going further than what is required under the Data Protection Act. Those are already included in the processes of the NIDS as it's being developed. Now, it was previously recommended, again, by two other individuals from the technological sector, that for the committee's consideration to not only include it within the processes, but also to include them in the bill. And those processes would be applicable to all the identity information, including transactional metadata, right? Note, however, that the transactional metadata that is being referred to in this particular clause is in direct relation to the data protection requirements to have that, to keep that transactional data so that persons can request under clause 24.6 to find out what information is in the system on them, as well as what has been happening to that information. That's the sole purpose. So disclosure of transactional logs on that data would not be up to the individual as it relates to any information on them, wouldn't be anonymized, but in all other cases, anonymization, pseudonymization, and encryption would be methods of protecting transactional metadata. As it relates to the fourth schedule, where you had indicated that particular instances of offenses did not correctly fall within the regime of the second schedule, the committee has in fact indicated that it will be revisiting the offense and penalty regime, but we just wanted to point out though that the POCA indicates in clause 6.1, which speaks to the types of offenses that do go into the second schedule, that the defendant is living a criminal lifestyle that provides financial benefits. And a part of that, the act goes on to indicate that criminal lifestyle constitutes conduct forming a course of criminal activity from which the person benefits, right? However, he must also be convicted of other types of offenses, which of at least another type of offense, which directly show that this is there. So for instance, as it relates to providing false information or making a false statement of a material nature, so he does that, then he utilizes the card at a bank to gain whatever it is that he wants to gain, and that will indicate the course of activity. And that is why it was thought appropriate for those offenses, though they're not clearly financial or not on the face of it financial, it will be a part of the course of activity. And I think I answered all of the concerns.
I think that was a comprehensive response, Jamaica. Thanks. I want to thank Mona Law. The comprehensive response will also be sent to you. If you have other concerns or points to make, please free to submit to the secretary as soon as you can. But we want to thank you for the time you spent to study the bill. And some of the points you made are very important, which the committee will take into consideration when we deliberate. So thank you, and please remain, on, because we have two good further extensive submission. The Office of the Public Defender, I think the Public Defender herself is with us. Are you with us, Mrs. Arlene Harrison? Henry? Can you join us now, Arlene? Thanks, Shazida and Ali and Mr. Shackelford. Okay, now we're going to have the Public Defender. All right, Public Defender, can you put on your audio? We see you, but your audio is not on.
Right, it's not touch screen. Good afternoon. Chairman, thank you for having us. Sure. Members of the Joint Select Committee, good afternoon. We also thank other presenters who have gone before us. As you can see from our submissions, Chairman, we share some of the concerns raised by others, and I believe that it therefore means that our submissions will be much shorter because we have already submitted our considerations on this matter. We first of all want to go on record as saying that we do not object to the creation of a unique number and card carrying that number for each Jamaican and those ordinarily resident on the island. We believe that administration, processes, bureaucracy can be greatly simplified with this unique form of identification. We, however, Minister, as you know, with our specific mandate under the Public Defender Interim Act, has a specific mandate for the protection of constitutional rights. So whilst we support a simplified system of identification, which we understand to be one lifelong number per person and card bearing that number, our concerns are nonetheless relate to the massive amount of information required of every citizen and those ordinarily resident on the island. Before I go into that, members of Joint Select Committee and other contributors who may still be participating, we wanted to look at the role of the inspectorate. And we see that the authority, which is the NIDS authority, we have shortened it, is subject to the directions issued by the inspectorate in relation to matters of operation regarding compliance and so on. What we're not clear on in relation to the establishment of the inspectorate is whether or not it is intended to be an oversight body, a supervisory body, a body that can receive complaints from persons who are participating in the process who may have a complaint against any aspect of the process in which persons engage, and generally against the National Identification and Registration Authority. So we seek clarification on that. What our concern is, Chairman, members of the Joint Select Committee, is what we call the massive amount of personal biographic data that is required to gain enrollment. According to the proposed legislation, an individual applying to be registered may be required by the authority to produce personal biographic data and details on himself, which includes not only about himself, but other members of his family. So if we look, the first set of information required relate to full name, including any names prior to change, whether by deed poll or marriage, date of birth, country of birth, place of birth, names of mother, father, whether the individual is male or female, place of residence or other places of residence, nationality. Of course, that is in the case of an individual who is not a citizen. Period of residence in Jamaica, marital status, name of spouse if applicable, and occupation. It seems to us, Chairman, that all of the above, which is 12 pieces of information, would be unique to a specific individual. But we notice that the process of enrollment takes into account facial imaging, fingerprint according to the Fingerprint Act, and a manual signature, which is the biometric information. The concern about fingerprint, Chairman, is that under the Fingerprint Act, it can include palm print and footprint. In addition to which, the Fingerprint Act itself has a regime of procedural guarantee as to how fingerprint and other matters under the Fingerprint Act are utilized. and taken. And the concern clearly is that all of that information to which we referred previously relates to an individual. And these are unique features of this individual. But then further information is required again. Taxpayers, and this is not for verification, taxpayers registration, driver's license, passport, NIS, path electoral registration number. We point out that there is a lack of harmony between the proposed section 11.1 and section 11.2 in that 11.1 appears to say someone applying to be enrolled may have to produce all of that which I've referred to previously. That is the 21 bits of information, which includes the biometric data. And then the proposed section 11.2 suggests that the 21 unique identifiers is mandatory, or at least a condition precedent to being enrolled. As section 11.2 says, if the applicant is unable to supply one or more of the items of identity information listed in 11.1, that is the 21 unique identifiers, then enrollment is discretionary. So there seem to be, we're not clear on how those two provisions can be harmonized, and we seek clarification on that. Now, the verification process, Chairman and members of the Joint Select Committee, requires the applicant producing another 10 bits of document. 10, birth certificate, passport, driver's license, electoral registration, identification, marriage certificate, deed poll, identification issued by an educational institution as defined under the Education Act, identification issued by your current employer, a decree of dissolution of marriage or nullity of marriage, and any other document containing identity information of the individual. So what the intended legislation seeks to do is to collect substantial personal data on an individual and 3 pieces of biometric data. Now, Chairman, our understanding is that the legislation has identified the aims and objects, which is basically to establish a system of identification of individuals. And it is to provide a legal framework for a national identification system that provides safe, reliable, and robust verification and authentication of identity information for citizens of Jamaica and persons ordinarily resident in Jamaica, thereby strengthening identity security, cybersecurity, and the simplification of bureaucracy. It appears to us, Minister, and our submission is that this massive data collection on individuals go beyond establishing a simple system of a unique number and card carrying that number. And the question we ask is that amount of data necessary or potentially to be collected and stored, necessary to establish the identity of an individual? And we are constrained to say the material required or potentially to be collected seem to be way more than that required for the stated purpose of the intended act. In addition, verification, though verification is stated as to what documents you are to come forward with now, what the intended legislation says is that the authority can take all reasonable steps to verify that identity information. And this provision or intended provision requires or at least suggests that the authority will or could potentially conduct its own independent investigation to determine the authenticity of the identification information provided by the applicant. Chairman, members of the Joint Select Committee, we also have, as other groups have pointed out, concerns about the cooperation with other public bodies contained at the proposed Section 8.1 and 8.2. It appears that those provisions are intended or designed for the sharing of information on individuals enrolled with the authority across ministries, departments, and agencies of government. You see, and we see clarification on that, because what really seems to us is that when all the material collected on all of us is put together, biometric data, biographic data, that national database would have stored key aspects or benchmarks of an individual's entire life and that individual's life story. The material required to be enrolled reconstructs an individual life history from birth to death, from primary and secondary sources. Chairman, we have come to the view that what appears to us to be the intended connectivity and sharing of identification information are not justified, and there is no justification offered for this massive data collection, which we say result in trespasses and intrusions in a citizen's personal space for the purpose merely to assign each individual with a unique number and a card bearing that number. And we believe that this massive data collection of citizens across the island and those ordinarily resident on the island ought to be a concern for all of us. And we believe that the collection of this massive amount of data has to be justified and proportionate. Moving from that point, Chairman.
But before you leave that point, why, I think it's fair, I need to stop you a little bit and ask the question. Firstly, there won't be any sharing of data from the NERA with anyone else, because that would be, releasing private information. But this Section 11, to get the identity information, collecting the 21 pieces of information, as you point out, it's not mandatory. It says may, firstly, and it means that what is important is that the identity information uniquely identify the person. So why I say that is that you will appreciate there might be many persons with same name. So that is not a unique identification. There might be many persons with similar, mother and father, and so on. Obviously, facial features, fingerprints, manual signature are unique. One cannot deny that. And the facial features, the signature, and the fingerprints might be unique to identify the person. But to the extent that, I mean, you know, the name, the residence, place of birth, mother and father, don't you see that that generally sort of convey and focus that this individual is unique to all this information?
So, Chairman, let me answer you.
Mm.
We have pointed out in our submissions that there is a lack of harmony between proposed section 11.1 and section 11.2. Because section 11.1, and if you look at paragraph 28 of our submission, we say, yes, and we quote it. We say the authority may. So that is suggesting that it is not mandatory.
Right.
Yes, but if you join that up now, Chairman, with section 11.2.
Which is also me.
Pardon?
Section 11.2 is also me.
Section 11.2 says, where an applicant is unable to supply any one or more of the items of identity information, that is a 21 bits of information,
right,
then enrollment becomes discretionary. So it seemed to suggest, Chairman, that the 21 bits of information required in the previous paragraphs are required to guarantee enrollment.
No, it can't be necessary.
Absolutely, Chairman.
No, let me give you
to differ on that because
but let us give you an example. Suppose a person doesn't have a driver's license, doesn't have a passport, because they don't want to travel, or they have never traveled, they don't have a driver's license, and I don't think that would be disabling the person from getting the NIC. In other words, the fact, obviously, if you have a driver's license and you have a passport, it assists in determining the identity of that person. But the fact that they didn't have a driver's license or a passport, or for that matter, even a TRN, it won't disable them from getting this card.
And I'm agreeing with you on that, Minister.
Yes.
What we're saying is that as worded, there seemed to be a disharmony between the two provisions. I agree with what you're saying.
Yes.
All we're saying is, as currently expressed, in the two provisions, there needs to be, I would say, a better refinement, because I agree with you. You could go into register, but you're an 18-year-old and you don't have a driver's license, or you don't have
a passport,
certificate, or a passport. That would not disqualify you. But what it says, what the current provision says, Minister, is that where you don't have one or two, then it becomes discretionary.
No, but I mean, obviously, you see, if it is obvious that the person, being a 16-year-old, for example, don't have a driver's license, has never got, don't have an elector registration number, is not on part, doesn't have a national insurance number because they have not worked, and for that matter, you know, is not married, and therefore doesn't have a marital status and no name of spouse. I mean, in other words, there might, in that 21, there might be 10 or more that a person may never have at the time of registration.
That is correct.
Right.
And therefore it would mean, Minister, that the million of citizens of which you speak would not properly fall, being able to provide.
No, but this is Saracen. Because they will never have those, that information. For instance, a person 3 years old will not have 10 or more of this information. That will not disable them from being registered.
We understand that, Minister. What I'm saying is that the provisions of 11.1 and 2 needs a better harmonization.
So you're talking about the drafting. Are you talking about the drafting then?
The drafting and the wording of the legislation.
Okay.
But I'm only asking that there be harmonization between, it comes over to us as being a bit of a disconnect, though we understand and accept what you have said, because that is also our interpretation.
Right.
But in relation to the person who has all of the information, Minister, say older citizen in the country, working here for many, many years, we also believe that that is a requirement of providing a great deal of information about one's personal life to become registered. And we will disagree on that, Minister.
Okay,
and
all right, no problem. All right, okay, no problem. Continue.
Identification information, Minister, of participants in Justice Protection Program, the intended section 13. And Minister, we know that the Justice Protection Program, an integral part of our criminal justice system, and this is all over the world. And we know of the very horrible culture that we have in terms of many persons not wanting to come forward to give evidence and not wanting to give information to the police. We have a concern with the intended section 13. And it reads that where the authority receives a notification under the Justice Protection Act as to any matter which may concern the identity of an enrolled individual, the authority may act in accordance with such procedures in respect of enrolled individuals who are participants under the Justice Protection Program as are agreed with the administrative center. The challenge that we have, Minister, is that the proposed legislation, we have not seen the offer of adequate protection to the individuals in the Justice Protection Program, as identity information appears that it can be given on an agreement between the authority and the administrative center. We want to suggest that the legislation should provide more detail as to how these persons will be treated under the new regime, and with specific provisions to put in place the continued protection of their identities, because that is the basis of the justice protection system. It's a concealment of identity, and in many instances, as you know, Minister, the complete change of identity, the change of location, sometimes the change of countries in which they live. And we have a concern, Minister, that we perhaps need to look at that again to make sure that those persons are protected.
I think you will appreciate, Mrs. Sarsa-Henry, that is something you don't necessarily want to reveal too much. And the reason for that is that as you appreciate the secrecy of persons under the justice protection system, where they might even change facial features, you agree? In order to protect their identity. So that is not something that you want to spell out too much in legislation. You have to
we weren't asking for it to be spelled out as though A, B, C, and D. But what our concern is that it is now subject to some agreement with an administrative center. You see, Minister, in our work, we have had several complaints from persons in justice protection programs. And we would want to make sure that the identities of these persons remained virtually sealed.
Not only sealed, but where it is changed, for example, it doesn't become known.
Precisely.
No, but, and I'm saying,
and this minister appears to allow a leeway in that area. Read, Minister.
I understand, but I'm trying to say
on it carefully.
What I'm trying to say to you is that something that you would want to spell out in the act.
Minister, we are saying that that there needs to be more.
Okay, all right. It's something we look at. No, we look at it.
I think we have to look at it, Minister, and I'm not suggesting that we put everything in the act, but there needs to be that guaranteed protection to those persons who give up their freedom to be in this protection program.
And what you're saying is absolutely correct. So the necessary protective device will have to be put in either in regulations or some understanding is clear.
Exactly.
No, I understand.
Absolutely. Minister, in relation to accredited third parties, intended section 25. I'm not going to spend too much time on it because it has already been mentioned by other groups. We're not sure. There's no definition, so far as I recall, as to who an accredited party is.
Right.
And perhaps we need to have that, we need to get a greater appreciation. And also how the data they get is kept. Moving right along, Minister, our paragraph 48, voluntary nature of enrollment, which we support. We agree and support the recommendation coming from the Christian Lawyers Fellowship, in that it needs to be stated in legislation that persons shall not be denied service, whether from public or private sector, by virtue of a decision not to enroll. I heard your comments on that previously, Minister, but I think it needs to be put in the bill more in by way of a positive statement in the bill. Persons who are not enrolled should not be denied service.
You can't enforce that with the private sector, though. The private sector can always determine what they require as identification. I mean,
Minister, the private sector.
I'm not necessarily saying, you know, that the private sector must accept the NIC. In other words, the bill won't say that, but you can't say that the private sector must accept. In fact, what the Christian Fellowship is saying, that we should put in the bill that people should accept either the NIC, the passport, or the electoral card. The private sector may say, we are not accepting any of those. We want a verification from your mother and father. You get me?
We understand the nature of the private sector, Minister, but we also know that the private sector has its own system of identifying its customers. Know your customer. And the private sector is also subject to the laws of Jamaica.
No, but that's something that we have to be very careful how we tell any private sector that has a discretion what that they must accept. Because what is being proposed there is that they must accept, say, either the NIC, driver's license, or passport. You know, as I do, that driver's license have been compromised. If you put that in the law, from a man goes and says, this is my identification using the driver's license, then the private sector would be bound and say, you can't do that.
I would never go that far, Minister.
But that's what the Christians are saying.
No, in principle, we agree with the position. I would never go that far.
Okay,
because I do believe the private sector, like any, whether small or large business, has the right to determine what is their mode of operation and what they regard as acceptable as part of their business process. So I would not go that far. I would just want to see no one being penalized or denied access for not having enrolled.
No problem.
Minister, we believe that this legislation has a very long arm. And as you know, the Charter represents a body of values upon which our democracy is founded and agreed. And we believe that the long arm of this law stretches into the area of privacy. And as you know, Minister, we have a whole freestanding provision in our charter, far more developed than many countries. And it is one of the pillars on which the free and democratic society as Jamaica is founded. So we have concerns. And we have concerns that the amount of data that is required may be disproportionate to meet the needs of the legislation. Because that the NIDS, Minister, would not eliminate the need to have a driver's license, which, as you know, is the authority to drive on the street.
Right.
It would not eliminate the need to have a passport, which is an internationally recognized document from one country to the other, to leave Jamaica as the Constitution allows us and to enter another country. It's a passport. So it does not eliminate the other forms of identity. We're concerned about proportionality, which takes me, Minister, right to section 24, which is the provision that has caused us serious concerns.
Okay.
Paragraph 62, Minister. Previously, you had mentioned that, you know, the identity information required by the JCF, and which will be permissible under the Act, if the police were able to persuade the court.
No, not the police, the Commissioner of Police.
The Commissioner of Police, Commissioner of Police, but we know that it is a delegated authority down to the level of superintendent. We understand that. We want to submit to you, Minister, that this is not a matter of persuasion, for the reason being that normally in court proceedings, the judge may be persuaded by one side or the other. This is a situation, as is proposed, where there's only one side before the court. It is only one side before the court. In addition to which we say and submit that once the application is in good order, meets the requirements of what is outlined in the intended bill, the judge, I don't think, has much of a choice, Minister, in terms of the judge, it seems to us, would be obliged to grant the order.
No, I'm not too sure I agree with you.
Well, Minister.
But look, if you look at section 24, section 24 specifically makes the point that the judge has to be satisfied. Look at subsection 3. if you look at subsection 3, the judge has to be satisfied that the information being requested could not be obtained otherwise.
We understand that, Minister. Yes. We understand that the standard is that the judge has to be satisfied. The fact of the matter is that there is one side presenting before the judge. So, very much in the same way, Minister, when years ago there was the amendment to the Evidence Act, and people had to learn how to come within the parameters of the Evidence Act to get the orders. We are saying that once those parameters are satisfied and properly learned by the JCS, then there is no opposition.
Mr. Sergeant Henry.
Yes, yes.
We have to stop you here, you see, but unfortunately we have to finish up by 2:30 because there's another joint select committee coming on. Now, I have to also apologize to Jamaicans for Justice, but what I'm going to suggest, Mr. Sergeant Henry, is that when we meet next week, we ask you to just summarize your point.
Okay, that is fine with us.
And then you will just summarize your point, at which point give you another 5 minutes or so to summarize your point, and then the response from the NIDS team will be taken. Okay? I don't want you to finish and you leave and then we respond when you're not there. So I will ask you, I will invite you back next week to summarize.
And that is fine with us, Minister.
Good. And so the NIDS team will respond to you. Jamaicans for Justice, I know you're there, but we went on a bit longer. Is that Ranjay? Roger?
Yes, it's me, Minister.
No, I have to apologize. I must admit, as you can see, we went on much longer. And although we thought we might have had a little more time, but we're going to invite you back I think we're going to meet Arlene next week, Tuesday. We don't have Parliament next week, Tuesday. We're going to see if we can start sometime between 12 and 1 o'clock, so we can go on to maybe about 5 o'clock. So please listen out, we're trying to secure. I know there might be another meeting in the morning of the PAC, and therefore we're going to try and ask them to finish by 1, but if they finish by 12:30, we might come on early. Okay? Sorry to do this to you, Rajay. But
no problem. I appreciate the extra time you're going to give us as well.
No, I must admit, your submission is one which I've read with great, not all, but read a lot of it with some interest. So we look forward to your presentation sometime next. Not that you to get in all 4 hours, there are other presenters.
And there was some feedback, I couldn't hear that.
Sorry.
No problem. I understand. And we look forward.
Presentation, okay?
No problem.
All right, so because the Joint Select Committee on the sexual harassment, they gave us half an hour and we don't want to interrupt their beginning. We're going to stop at this stage and to thank all the presenters, including you, Ranjay, for being on, and to really hope you all can join us again next week. I think we meet on Tuesday. And we want to thank all the NIDS team and everyone who participated, and to wish everyone a good afternoon. Can I have a motion for adjournment, members of the Joint Select Committee?
So moved, Mr. Chairman.
Thank you very much, Minister Johnson Smith, and thank all the members of the Joint Select Committee. Please, all the documents have been emailed to you, and we are hoping we can finalize the time for next week, Tuesday, to resume the contribution from the public defender. Then after the public defender will be Jamaicans for Justice, representing a number of other organizations. Thanks everyone for being with us this afternoon.
Thank you. Good.